The Council for First and Second Respondents have argued that the documents have been produced selectively. We have made an application. This is actually part of the application for scrutiny for the first and the second respondents to avail all their documents, all the internal memos, all minutes of their meetings, so that we can have a full picture of what was happening. And so the argument that we have produced the documents selectively cannot stand when those are what the petitioners were able to find in the public domain. Thirdly, the considerations of public interest outweigh the third respondent's objection to these documents being considered or being looked at as part and parcel of the factors that the court must make a determination on in the petition. The spirit of Article 35 of the Constitution, Article 10, is one of transparency, sorry, my Lord, the spirit of the Constitution is one of transparency, and Article 35 of the Constitution acknowledges that every citizen has the right of access to information that is held by a public officer or institution. To this extent, the fact that the documents that we already have in our possession are in the public domain, they cannot or should not be removed from the court record and measured against the application to have all other documents produced before this court, then, my Lord, the public interest outweighs any right or any prejudice that the third respondent claims it might have suffered. Finally, the aim of these proceedings and of the court is to promote the values of the Constitution and the principles to advance the rule of law. If these documents, these memos, the communications between the respondents, what they have publicly put out there, help the court to arrive at a just and fair determination of the matters before the court, then the court must allow them to be part and parcel of the record of the court and of the petition. Much obliged. Unless there are questions for me.
Ms. Soweto, you have not addressed Section 27 of the IBC Act. You have not addressed Article 50, Sub-Article 4, which were raised by the applicants. It's important that you address us on those two provisions.
I beg your pardon, my Lord. I agree. In respect to Article 50, Article 4 of the Constitution. My Lord, just to read, Article 50 says, evidence that is obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be included if the admission of that evidence would render the trial unfair. Number one, we have not obtained this evidence illegally or in any manner that violates the third respondent's rights. Indeed, that is the argument that I made. The third respondent has not shown how his rights would be violated. These are documents that have been in the public domain. My Lord, and just to comment on the issue of the documents being in the public domain, some of those memos, even after having been publicized widely in the print and electronic media, the first and the second respondents did not come out to object to them or in their proceedings. Secondly, on the question as to whether they would render the hearing of this petition unfair, that is a question for the court to consider. You have not been shown how the documents would render the hearing of this petition unfair. And then thirdly, common law principles which our courts apply show that evidence is, even if illegally obtained, which we deny, is admissible if it is shown to be relevant to the matters before the court. On the question of Section 27 of the IBC Act, the first requirement under Section 27 is that the Commission is under a duty to publish and publicize all important information within its mandate affecting the nation. That is the basic requirement. Subsection 2 addresses where a citizen requires that information, even without the IBC publishing it or publicizing that information. Therefore, my lords, the requirement that subsection 2, the request for the information, whether made or not, does not nullify or change the fact that IBC itself is under a duty to publicize and publish information within its mandate that affects the nation. This again is in keeping with the principle of transparency and openness. The questions before this court are such that it is important to see the transparency and the openness within which the IBC operated.
You should wind up, Miss. Your time has run out.
My lord, unless there are other questions. And then finally, as I'm reminded by my senior, The IBC has a positive obligation and duty to provide information and access to its documents and to its internal workings. That will be all.